Parliament.
Paul Raymond Ho.
Thank you, Mr. Speaker. Labor supports the Building Act review, and our focus is on the protection of consumers, building practitioners and building consenting authorities, namely ratepayers. For that reason, we cannot, at least at this stage, support the passage of this bill. We look forward to supporting any new bills that provide such protection. Two events, as explained in my earlier contributions, would have played a certain role in affecting our position. It would make more sense to focus specifically on issues in relation to dams and hold back the provisions that deal with the consumer issues in relation to residential properties. And the second one is concerning the review of the non-ductile column buildings built between 1982 and 1995 with 3 stories or more. The purpose was to establish if there were any buildings with similar design flaws to the CTV building that collapsed in the February 2011 Christchurch earthquake, killing 115 people. The current legal regime does not give authorities power to compare the at-risk building owners to have their at-risk buildings assessed in the interests of the public safety. The Minister had earlier indicated that he would explore options to address the issue by introducing, for instance, SOP to this bill. But none of the two events occurred in terms of the progress of this bill, and therefore our position, as outlined in our minority report, has remained the same. It is more in sorrow than in anger that we have no other choice but to vote against this bill. Mr. Speaker, there are a number of issues I wish to bring to the attention of this House. Firstly, the definition of the buildings. The Building Act, as its title suggests, is meant to cover all the infrastructure, commercial and industrial buildings and structures. However, one major problem with drafting of both the Building Amendment Bill number 3 and number 4, and indeed the entire Building Act review, is their obsession with homes, dwelling units. It appears that they have confined the definition of buildings to that of homes, dwelling units or residential buildings. Given the very serious problems that have come to light with large structures, especially stadia, the Building Act review and the two bills introduced to implement its policy decisions should have covered more than dams and dwelling units. The Supreme Court's decision on the Spencer on Byram case has reinforced the view that the Building Act review and the bills introduced should be taking a wider look at those issues. It is therefore important to note that we are only dealing with part of what the Building Act is meant to cover. And further, the number 4 bill addresses only residential buildings and orderly dams. Secondly, we found the rationale to replace code compliance certificate with consent completion certificate less convincing. We agree with submissions and views that this is a step too far until such time as the licensed building practitioner regime matures. According to them, at this stage, the regime is more a system of ticking boxes than a means to upscale the industry. The new CCC is significantly different from the old CCC, and this change will almost certainly have detrimental effect on the consumers seeking redress for severe loss. And I note the Minister has not triggered the new CCC regime for good reasons, and that has reinforced my view. Thirdly, Contrary to the purpose of this bill, the measures introduced would reduce the means by which an aggrieved owner can seek redress for significant financial loss and hardship. One overarching concern from the submitters is that this bill sought to redistribute the responsibility and liability from, and therefore intended to ring-fence the building consent authorities in the event of a building failures. We agree that the liability that has until now rested with the consenting authorities as the last man standing is unacceptable. This is because ratepayers eventually have had to bear the cost of negligence claims brought against the consenting authorities. It is equally unacceptable that it is now the consumers who will be left to pick up most of the bill for any claims resulting from substandard building work. Further, new measures have been taken to ensure that builders and other parties that may be responsible for serious defects will have sufficient assets and insurances to cover their liabilities. And Mr. Speaker, that's the reason why this afternoon I released the Labour media statement and urging the government to include home warranty insurance scheme in the Building Act review. I support two of our largest city councils, Wellington and Christchurch city councils, and a number of other submitters that have called upon the government to introduce a home warranty insurance scheme. As pointed out by the Homeowners and Buyers Association, if responsible parties for defective building work have either gone out of business, died, or left the country, the consumer is left exposed and faces having to cover the costs. Building law should be amended to offer greater protections, not to reduce them. Mr. Speaker, the fourth point with regard to the company failures. Concerns were expressed about companies that are formed for the sole purpose of a single building project and then liquidated as soon as the work is completed, leaving no legal entity that can be directly held to account for defective work that is later discovered. As it stands, the bill fails to offer consumers any effective remedies when left in the lurch by a $1 share company, despite the fact that the building sector's failure rate is higher than the rate of all businesses before 2003 and after 2008. Even legitimate contracting and subcontracting firms have often ceased to exist by the time defects have come to light. Number 5, a product warranty. We welcome an introduction of a responsibility provision for product manufacturers or suppliers. It is widely accepted that the leaky building saga was primarily caused by the use of inappropriate building products or systems or incompetence in or lack of adequate oversight of their application. The Minister pointed his fingers to Standard in New Zealand. He must be correct given his so experienced. However, given the complexity of the issue, particularly where prescribed compliance with the building code is often difficult to establish, the provision in its current form fails to address the problem adequately. In addition, it is essential that building product manufacturers do not escape liability because the specified installation requirements are impractical. All materials must be able to be installed on site using good carpentry, joinery, plastering or similar trade skills to reasonable tolerances and without the demand for laboratory-type conditions. Lastly, there are also drafting issues in terms of how provisions in this bill will be implemented. Many provisions in this bill are yet to be prescribed or determined by regulation without the proper definition it is difficult to put the clauses into context, which hinders the interpretation and implementation of the Act. There are other deficiencies in this bill, for example, the practicality of prescribed
Sorry to interrupt the honourable member. His
information
time has expired.
and notification.
Oh, so important.